It appears parties are present, their representatives are present. Anything further before we bring in the jury?
No, I just will note, it's going to be a few minutes, but I'm going to be playing a tape of it. The defense has a transcript, but there are 2 recordings. Just let the court know for timing if we get to it. I think the first one is about 17, 20 minutes in that time frame, and the second one is about an hour. So I was hoping maybe to get the first one before lunch, but I'll see how long my questions go. It might be fairly soon to get to.
Okay. All right. Would you bring in the jury, please?
As to the tapes and the transcripts, just so that we don't have to interrupt, we will be objecting to those on the grounds that they're hearsay and they violate our client's right to confront and cross-examine Ms. Tobie.
And on behalf of Ms. Tobie, we would join in that motion.
All right, just for, again, I'm not privy to the tape or the transcript.
Yes, sir.
I haven't seen it before now. Are you saying that the transcript does not accurately represent what is on the tape?
Well, I've just been provided the transcript, so I haven't been able to confirm that one way or the other. I don't have any reason to believe that.
Yeah, they've had the transcripts, Your Honor. I showed yesterday, made minor corrections, nothing substantive, just a little word here and there. They've had that, but they've had the transcripts for quite some time. We did take out the obvious references to, either prior jail or things like that that clearly couldn't have, but they've had those redacted for some time.
All right, is there an objection based upon anything having to do with the redaction?
Well, what I'm referring to is what I'm holding in my hands. I believe this was just provided to us this morning. I have the, what I'm holding in my hand is the transcript, number of pages 32.
Is that the hour statement, the second one?
I would imagine.
No, it's both. Your Honor, and I explained this, maybe it was Mr. Quarles, maybe he didn't talk to Mr. Mott, but they've had a transcript. We made slight corrections. I gave that to them yesterday, highlighted the portions that we were making the corrections on, which he has right in front of him there. He's got the other one. The corrections are minor, so.
All right, so the transcript you're saying was furnished some time ago?
Yes.
Except for the
Minor corrections.
some corrections.
That's characterized.
Okay, let's bring in the jury. And you can make your objection, by the way, during that time, and I'll make a ruling. All right, the jury is now seated. The parties are present. Their representatives are present. Mr. Davis?
Ms. Blake, I just want to back up a moment with regard to something you mentioned about not having a way to contact Mr. Cooper. You mentioned earlier he had called your residence one time and you went by the shop numerous times.
Yes, sir.
Did you have any way yourself that you knew of to contact Mr. Cooper other than going by the shop?
No, sir.
When he called you at one time, did you keep his number or write it down, have a way for you to contact him?
I didn't have his number. He called me.
Right, that's what I'm saying, but I just want to make sure that through that, did you have any way at all to contact him?
No.
In your mind, after the murder of Mr. Cataneo, was there any reason to try to get in touch with him until Ms. Tobie got the insurance money?
No, sir.
During the time we were talking about Ms. Tobie being at the motel, and then y'all came back, and then she went back and was hanging out over there. First of all, did she make any comments during this time frame about leaving the area or going to another country, anything like that?
She had said she had mentioned to me that she needed to get her passport in order, and she wanted me to get one, and I said I don't need one.
Were you concerned during this time frame about being caught for your involvement, and was that something on your mind?
Yes, sir.
Did you even at times think that you were being followed or anything like that by the police?
Yes, sir.
Did Ms. Tobie mention to you anything about fears she had about the police and watching and things like that?
Yes, sir.
Was there a concern by you or Ms. Tobie that the phones were bugged?
Yes.
Did you have a discussion with Ms. Tobie about the fact that your phones are probably bugged or something like that?
Yes, sir.
Do you feel in your mind that there was some friction developing between you and Ms. Tobie as time went on?
Yes, sir.
Did the police ask you to come in and talk to them on October the 5th of 2004?
Yes, sir.
And did you go in and talk to the police?
Yes, sir.
Did you tell them the truth at that time about
sir.
what happened?
No, sir.
Were you thinking about telling them at that time when you went in? Was it?
Yes, sir.
Were you scared?
Most definitely.
Did the police talk to you or lead you to believe that they thought you were involved in some way?
Yes, sir.
Did they mention the fact to you that they felt that Karen Tobie was involved?
Yes, sir.
Did they mention Tysjohaun Cooper and the fact that they thought he may be involved?
Objection calls for his opinion that's inappropriate and irrelevant, invades the province of the jury.
If I may respond briefly.
Hang on, just a moment. All right, go ahead.
Ruling, Your Honor?
No, I'm going
You
to
will.
respond. Thank you, Mr. Munson. That question is not being offered for the truth of the matter asserted. In fact, all my questions about the interview are going to the state of mind that it caused Ms. Blake to have and what caused her to take action the next day. So everything the police told her, again, whether it was truthful or not, is irrelevant for the purpose of the question. It's more of the effect it had on this witness.
The state of mind being that which resulted in her giving a statement at one time versus another? Is that what you're saying?
Well, no, sir, it's the police mentioning people who they felt were involved would lead her to believe that they're closing in on us.
Okay.
And it
All right.
led her again, that's
Your Honor,
Yes, sir.
Jack, that would call for speculation on her part of what the cops were thinking about, what she was thinking in her mind.
Well, for the limited purpose of it provoking a response from this witness, then I'll allow the question, not for the truth of any matter asserted in that material you may present to her. And the jury is not to worry about or be concerned with the substance of the matter, maybe questions that were asked of her by the police, but rather solely did this provoke some kind of a response in her thinking.
For the record, can we make a ruling, Your Honor? Are you denying my objection?
Yes.
Yes, thank you.
Well, I'm denying it, but I'm putting the admonition to the jury
Yes.
for that limitation of the evidence they received.
Yes.
Okay, go ahead.
Did the police mention Karen Tobie?
Yes, sir.
Did the police mention Mr. Cooper?
Yes, sir.
Did the police talk about accessory, principal, things of that effect under the law?
Yes, sir.
Did the police even give you a copy of the statutes pertaining to principal accessory?
Yes, sir.
Did the police make statements to you about the activities that Ms. Tobie was engaging in at that time?
Yes, sir.
Did the police show you a copy of what you believe to be a driver's license of,
Yes, sir.
of Ms. Tobie?
Yes, sir.
Did the police tell you about what Karen Tobie's lawyer was saying to them and to the prosecutor?
Yes, sir.
Did they tell you that they were telling them to look at you?
Yes, sir.
Did that concern you?
Most definitely.
Based on the information the police were giving to you, what thought process did you have in your mind about where this case was going?
I felt that she was trying to push this all off on me.
Did the police indicate to you that they were hoping you would tell them the truth?
Yes, sir.
Did you tell them at the interview that you were not telling them, that you didn't intend to tell them the truth at that time?
At that time, I said I was not willing to make a statement.
Well, you talked to them, right?
Yeah, but
Do you mean a truthful
a
statement?
truthful statement.
When you left that interview, were you upset?
Considerably.
Did you go talk to Karen Tobie, confront her?
Yes, I did.
What did you confront her about?
They had showed me a photocopy of her driver's license, and I was upset that she was having me drive her all over the place, and yet here she had a driver's license. And so I confronted her about that.
Well, what'd you do?
I hit her in the chest.
Were you mad at her?
Oh, to say the least.
Did you look around to try to find a license?
I emptied her purse out
Where'd you empty it?
on my floor.
On the floor?
Yes, sir.
Did you make any statements or comment to her about anything else the police had told you about trying to pin it on you, things of that effect?
Yes, sir.
What was her response to you?
She said, "Don't worry about it. They have nothing."
Did you know at that time that she actually was consulting a lawyer in Orlando by the name of Jim Dowks?
Yes, I did.
Had you met him before?
Yes.
Even though you met him, had you ever been present when he was talking to Ms. Tobie about the case, or were you ever present during meetings at all between
No.
them? Would you drive her to her appointments?
Yes, sir.
This interview talked about when the police were telling you these things and you had the mindset you described. The next day, on October 6th, did you drive Ms. Tobie to an appointment with her attorney?
Yes, I did.
And where was that?
In Orlando.
What did Ms. Tobie tell you when she came out of that meeting with her lawyer?
Her lawyer had told her that she needed to distance herself from me because they were looking at me as the principal in this murder.
And had you looked at the principal statutes?
Yes, sir.
About what principal assisting, what that means?
Yes, sir.
Did you know in your mind whether Karen Tobie was attempting to point the finger at you? Did you know one way or the other?
I had my doubts because she was acting very, very strangely towards me.
When you were driving back from Orlando, were you starting to make a decision in your mind?
Pretty much
What decision were you making?
that I would probably, within the next day or so, end up going to the police.
Did this cause, were you torn emotionally on with regard to going and giving it up to the police?
Definitely.
And how so?
I consider Karen like a daughter. We'd been very, very, very close. We did everything together.
Were there any statements made even on the way back from the lawyer about sticking together or something along those lines?
Yeah, we had a little thing we used to do that we would stick to our story and we pinky swear. You know, you do this.
Did you do that on the way back from Orlando?
Yes, we did.
And what did that mean in your mind?
To keep my mouth shut.
And did you take that to mean that she would keep her mouth shut too?
Yes, sir.
When you got back, I assume you drove back from Orlando back to your house?
Yes, sir.
Did you speak to anyone on the telephone that day?
Not right away.
Did you have a phone call with Janet at all sometime?
Yes, it was later on in the afternoon because Karen had left with one of her friends.
Okay, and first let me ask, who is Janet?
That is Karen's sister.
And where does Karen's sister live?
It's in Seattle, Washington.
What was your purpose in calling Janet?
To ask,
Relevancy.
Overruled. This could be relevant. Go ahead.
What was your purpose in calling her?
I wanted to know what to do.
Did you tell her your dilemma?
Yes, I did.
And I don't want to get into the details of your conversation, what she said, but in the end, did she tell you who to take care of?
Take care of myself.
And here's that.
It is hearsay, Sister.
May I please be heard briefly on that? Again, it's not all.
Objection, could we do this outside the press, please?
Yes. Be calm, please. With regard to the prior ruling, counsel may inquire on a very limited basis as to the gist of that statement.
Your Honor, just for clarification, is my objection sustained or is for the record?
It is overruled but the court is limiting this question and the testimony.
Ms. Blake, as a Procedural, I don't want any details of the conversation. My question is, at the end of the conversation, did Janet, Karen Tobie's sister, tell you who you should take care of?
Yes, sir.
And who was that?
Myself.
Did your conversation with Janet affect your decision whether to go and talk to the police?
Yes, sir.
And after that conversation, did you go talk to the police that day?
Yes, I did.
Did you make a phone call to someone?
Yes, I did.
And who'd you call?
I called Sean McGuire.
And did the police come and pick you up and take you to the Holly Hill Police Station?
Yes, they did.
And did you give a statement at that time as to events that occurred leading up to Mr. Cataneo's murder and events afterwards?
Yes, sir.
During that interview, did you go with the police out to an area to show them where you disposed of the gun that you mentioned earlier?
Yes, sir.
After giving your statement to the police, did you return home?
Yes, sir.
At that point, how were you feeling? Any relief at all from having talked to the police? Or
Objection, relevancy?
Relevant to that, Mr.
her state of mind, again, Your Honor, with regard to having talked to the police, it leads into other actions that you...
All right, I'll depend upon your assertion in that regard, so I'll overrule the objection.
Did you feel any relief at having...
Yes, definitely.
Did you agree to cooperate with the police?
Yes, sir.
In fact, the next day, on October 7th, did the police talk to you about putting a recording, a wire or a bug on you, and to talk to Karen Tobie?
Yes, sir.
And did you do that?
Yes, sir.
Did the police come to your residence there at 319 Center Avenue?
Yes, sir.
Do you recall that day when they came there, did the police also go next door to where Miss Tobie was?
I'm not sure if they did or not.
And who came to your residence there at 319?
Sean McGuire.
Did he place a bug on you?
Yes, sir.
Or where was that placed?
In my bra.
Was there any discussion with you, were you told to tell Karen Tobie someplace you had to be in order to see if that generated any discussion?
Yes, sir.
What were you to tell her where you had to go?
That I had to be at the Holly Hill Police Department at, I believe it was 4 o'clock in the afternoon.
On that day?
Yes, sir.
To your knowledge, had she said anything, or to your knowledge, did she know that you had talked to the police on the 5th and the 6th? I mean, did
No,
she-
sir.
And to your knowledge, did you know that you had told the police on the 6th about your involvement?
No, sir.
I'd like to show you, Ms. Blake, State Exhibit O for identification, which is a CD here, and State P as in Papa for identification, which is a transcript, 8 pages long. Have you seen these items before?
Yes, sir.
In fact, have you listened to this CD?
Yes, sir.
Is this CD an accurate account of the conversation you had with Ms. Tobie back on October 7th after being told to go tell her that you had to be at the police department later that day?
Yes, sir.
And have you reviewed the transcript along with the CD?
Yes, sir.
Does the transcript, is it substantially accurate with regard to what was being said by yourself and Karen Tobie?
Yes, sir.
Were you able to recognize your voice on the recording?
Yes, sir.
And were you able to recognize the voice of Karen Tobie?
Yes, sir.
And where it says Blake and Tobie, does that accurately reflect who was saying what during the recording?
Yes, sir.
At this time, the state would introduce State Exhibit O for identification into evidence. And we were not requesting State Exhibit P be entered into evidence, but we would request, in order to aid the jury, that they be able to use that listed in the recording.
Any objections to O, which is the recording itself?
Judge, we'd renew our pretrial motion in reference to this and object on the grounds previously argued.
Same ruling as to that.
Yes, sir.
Mr. Mott, do you have a specific objection to O?
I guess, Your Honor, on the grounds that it violates our client, Mr. Tysjohaun Cooper, the right to cross-examine Ms. Tobie. It's not admissible under any exception to the hearsay, or it's outside the scope of the conspiracy, so it's inadmissible. The alleged conspiracy.
Mr. Davis, any response to that?
Well, Judge, it doesn't, this is a conversation between this witness and Karen Tobie without reference to Mr. Mott's client.
All right. Just to be safe, I have not seen the transcript on that, and I'd like to very briefly read it.
Your Honor, can we ask for that cautionary instruction?
Yes.
Thank you, sir.
All right, this, ladies and gentlemen, is 2.6 of the jury instructions. You are about to hear recorded conversations. These recorded conversations are proper evidence, and you may consider them as with any other evidence. And by the way, for the record, I'm admitting O, which is the statement. You are also being furnished transcripts of the recorded conversation. The recordings are the evidence, and the transcripts provided to you are only as a guide to help you follow as you listen to the recordings. The transcripts are not evidence, and they're not being admitted into evidence of what was actually said or who said it. If you notice any difference between what you hear on the recordings and what you read in the transcripts, you must rely on what you hear and not what you read. So with that, the recording is admitted. That would be plaintiff's O, excuse me, state's O, and it is admitted as 9.
John, may I move the equipment out?
Yes.
If it's all right, if the desk can require, helps me out.
Yes.
Ms. Blake, I'm going to play this in a moment with the court's permission, but I want to ask you, I'm sorry I got this thing set up, but in this tape, when you're talking to Ms. Tobie, is she on the telephone actually during a portion of this conversation with her?
Yes.
And could you tell from the conversation who she's talking to? Could she tell?
I think there was actually 2 conversations.
Okay. And is there a mention when it talks about Jim in here? Is that the lawyer, Jim
Yes.
Dallas?
Yes.
And when a card is mentioned, what is the card in reference to?
It was one of his business cards.
One of his business cards?
Yes, sir.
Your Honor, may I go ahead and start?
Yes.
Excuse me, Your Honor. Sorry, Mr. Davis, but before he starts that, I do need to address the court at the bench, and I apologize.
May I go ahead and start?
Yes.
Stop the tape for a minute because I'd like to have a sidebar, please.
Okay. Ladies and gentlemen, we have some, oh, I'm sorry. I'm jumping ahead of the gun here. Okay. Ladies and gentlemen, we have some evidentiary matters to take up. Now, if this had occurred earlier in the day or later in the day, we would put you in the jury room or give you a break while we discuss these because it's going to be more lengthy than a sidebar can take care of. But given the time that it is, I think what we'll do is we'll go ahead and we'll give you an early lunch break and a longer lunch break because of the fact that we have to deal with these matters. So I'm going to, yes, please give back the transcripts. And I'm going to recess for you, not for us, but for you until 1 o'clock. That'd be about an hour and a half. Now, per usual, you may not discuss this case with anyone or amongst yourselves. You may not listen to or watch any media or view any media of any kind. You should not form any opinions or disposition on this case until you've heard all the evidence, the arguments, and the instructions on the law. Please place your notepads face down on your chairs. Is there any further admonition for this jury before they're released?
No, thank you.
All right, the jury itself is released until 1 o'clock. All right. From our sidebar, it does not appear that will we need this witness or
Not for,
No, Your Honor, not for
okay
this.
for this part?
No, sir.
All right. So shall we release her to begin later?
we would request that.
All right, release her for lunch and so on. All right. Okay, Ms. Blake has been released from the witness stand until we reconvene. We had a discussion at sidebar basically regarding the CD or DVD, whatever it is, the recording itself. Mr. Davis, would you?
Yes, sir. And the quality is much worse on this, I don't know if it's the actual player itself or the tape itself. Investigator McGuire went over this in the transcript and the CD with the witness to go over it, and the ones I've heard have been much clearer. So obviously there's either a problem with that CD or with the equipment. I'd like time just to talk to Investigator McGuire. Maybe it's as simple as changing the player. I don't know. If not, then I need to talk to him about how the other ones were clear, whether he was able to remove background noise or not, because there's a television playing, and in this player, for some reason, the television is coming out much louder than the conversation.
Yeah, as I noted to you in the record, I mean, I understood the first couple lines, I think, but beyond that, and it appeared to be because of background noise, I really couldn't understand much of anything. So do you need time to do that? Is that what you're saying?
Yes, sir, please.
All right. Well, if you do that, then we can reconvene here in, about an hour and 10 minutes. Say if we reconvened at 12, when that release jury, 1 o'clock, right? Then we can reconvene at a 1:45 and discuss this further, and that should give you ample time to find out or test or whatever you're going to do.
Yes, sir. And I also, for the courts, sorry to interrupt, but both of these CDs well, the one is in evidence already, so I'm going to need to, if Investigator McGuire, if we can be in the courtroom here, play it on here in order to determine what's going on. So
yes, you can do that, and we'll just break, and then we'll reconvene at 12:45, and you should know at that time how you wish to proceed.
yes, sir. And if possible, if you have time, what I'd like to do is the clerk, if we can leave out the other CD, so I can just make sure we're not going to count the same thing
Yes.
later.
Okay.
Thank you.
For record purposes, Your Honor, the police report,
Yes.
I have been provided what's purported to be a transcript of the DVD, which, so I'm referring to the right item.
Item P.
What item is it?
P is the transcript.
P is the transcript for this, and O is the CD, DVD, whatever it is.
Okay, P is purported to be a transcript of O.
Yes.
I have not had the benefit of reviewing this particular transcript. I've listened to a copy of what's purported to be O, which is the DVD. And the copy that I have is of similar quality to what I've heard in the courtroom. Now, I don't know if there's a cleaner copy or what, but I think it's very important that the record be clear exactly what O is. That DVD, is that an original? Is it a copy of something? Because the best evidence rule requires that we hear the best evidence. And if there's been a dubbing or an editing or a modifying or a quote-unquote enhancing of the original, then this court needs to know about it. And we need to know about it. And we need to know how that was done and who did it and under what circumstances.
In general, I agree with you. I don't know what specifics we're going to get into, but if there is a modification of an original recording, that doesn't make it inadmissible necessarily. Those kinds of scientific enhancements are done all the time, but we do need to know what was done, that it preserved the integrity of what the substance of the statement is.
And the jury needs to know that as well. I would request that happen at some point in time, that what they're hearing is not an original, but an enhanced, or
Okay.
however it's modified.
All right, I'll have to take a look at the rule on that, but we'll address
Well,
it.
Judge, certainly stated, if there is something, we're going to tell them anyway also.
Okay.
We want to
All
explain.
right, then that's not going to be an issue. All right, anything else before we reconvene at 12:45?
No, Your Honor.
Okay, court's in recess till 12:45.
All right. We'll be recessed.
Okay. The parties are present and the representatives are present. We were discussing before breaking for lunch about the CD, DVD that was in the statement that was in evidence being played to the jury, and what have you found out about that?
What I found out, Judge, is that Investigator McGuire had the CD that he took out with Ms. Blake, listened to it with her, went over the transcript. When he came back in for trial, I asked him to give me that CD, and I took that and wrote on it. When this happened here, he went back to the office and realized that he had given me another copy that he had. He made multiple copies, some for defense, had not given me the one that he listed with her. That's some other copy, and for some reason, we don't know why it's not as clear. He didn't do anything to any of the CDs at all, but he has the one that he listened to with Ms. Blake. And as I said, he inadvertently gave me another CD when I asked him to provide to me the one that he listened to with Ms. Blake. And I wrote on that one, and that's the one we were listening to. When he went back to his office and he knew it because it was in a yellow envelope, got that and brought it back, we listened to it. It's clear. I mean, there's a certain portion at the bottom of page 1 that we listen to it, you can hear it, it's difficult, but the rest, it's clear. It's a better copy.
For the record, I don't understand this. Was this a digital recording that was made, or was it analog?
No, this is a digital recording. What happens is you take the digital recording back, you download it on the computer, on the hard drive, and then all the copies are made, you can make the copy from the hard drive or burn the CD. So it's not as if there's an original. You have the digital, it's a digital recorder
I
that you
understand,
go back
and for the record, assuming the file hasn't been, the computer file has not been damaged in any way, then the 1,000,000th copy that's made ought to be identical to the first or fifth or 10th copy.
But we don't know why. Some are different. We have even the original with all of the parts. We took some dead portions out beginning and end because you had her driving for 10 minutes and then that's taken out. That part we played on here, we listened to it, it sounds better. And the only thing we didn't think of with regard to this copy, just found out recently there was some virus, might have done something. I mean, it's the same recording, it's just the background noises. But we noticed different. We sat here and played 3. We played the first one that was downloaded that has everything on it that the defense was provided. We played that. It sounds good. We played the copy that Investigator McGuire went out with Ms. Blake and played. That sounded good. And then we have this other one that has this noise on it.
So what do you propose to do here?
What I would like to do is for the limited purpose of the tape, call Investigator McGuire to testify about the tape that he took out of Ms. Blake and played, and explain that the mix-up there, and introduce in the copy that he says he played and went over with her, and introduce that into evidence. And part of this, Your Honor, it's very difficult for the witness, say Ms. Blake. She's shown a CD and asked, she's obviously assuming that's the one she listened to. It wasn't. But Investigator McGuire knows, no, this is the one we listened to. This is that tape. And I understand it's certainly discretionary with the court, but for the limited purpose, based on what happened, I'd ask to just call him for that limited purpose and then introduce the tape in, and then he would leave it at that.
Assuming his testimony establishes that, do you want to substitute the other CD, or do you want to put that into evidence as an additional exhibit and let the jury determine which one they want?
I prefer to substitute, but I can see also if both are in evidence, that's fine too. I don't really have a preference one way or the other. If it's substituted, we would certainly still keep it for identification purposes and have it remain anyway.
Yeah, it has, excuse me, it has an identification for appellate purposes.
Right.
The one that's now in exhibit, in evidence, I think is what, O? No, I mean 9?
Yes, number 9.
All right, and ID is O. We could keep the ID on it for appellate purposes, so it could be identified, and then substitute Exhibit 9, presuming that the testimony of the investigator is as you say. Comments from?
We would object, and 9 is in evidence. We don't want it out of evidence. We don't want anything to be substituted. For whatever reason, one copy that should be identical apparently is different than another copy that should be identical. As the court noticed, how that happens, whatever the technological explanation, if any, there may be. I'm not aware of any, but for some odd reason, we have a copy that's basically inaudible. And I haven't heard the copy that this is referring to. but I'm not doubting that it exists. I would ask that we have the opportunity before that copy is played to the jury that we listen to it ourselves. It's, I don't know how many pages, 12, 8
Okay.
pages.
All right, do you want,
Especially given, and if it pleases the court, so I'll be done in 2 seconds. We're objecting also to Exhibit P, which is the transcript. We don't believe that that is a fair and accurate transcript of what we've heard so far. And it's obviously someone's editorial opinion in terms of what was said, because I followed it the best that I could, which wasn't very well. I wasn't understanding anything that I was hearing, and it certainly didn't clearly correlate to this transcript that the jury, if the record would reflect, I believe the jury has already been provided that, unless I'm wrong.
they were provided with the transcript that the transcripts were then collected upon the break in the statement. I don't know where that was because I didn't have a transcript.
All right. So, and this is the last point that I'd like the court to understand. We want to make sure whatever it is that the state is going to introduce in addition to this, or depending upon the court's ruling in substitution of this, that we know exactly what it is. So could we listen to it? That's my motion.
I think so, given the difficulty.
Thank you.
Anything from the...
Your Honor, we would
defense team?
adopt the argument by Mr. Mott.
Okay. I'm not sure whether it's substitute or whether it's, because it'll still be for appellate purposes, it'll be available.
Well, I would like to be able to possibly consider anyways playing what's already been introduced.
Okay.
I mean, the jury's entitled to understand that there's two different...
All right, well, that has been moved into evidence, and it's in evidence, and if you want, we'll keep it in evidence.
Thank you.
And we'll add something if the testimony will support that.
Thank you very much.
Okay, so now do you want to have, I suspect we've got to have the jury in here for Mr. McGuire's testimony.
Yes, sir. Now, if the defense wants to listen to it before he's there with it, they want to play it real quick here before.
Let's do that. Let's bring him in, and then let's play the other statement, and then we'll bring the jury in.
Hello, Melinda. They were all just here. Yeah. And I went outside. I thought it was a friend of mine, and it wasn't. They were all standing out there on the sidewalk and everything, getting to the two houses. And I just handed the car to them, and they turned around and walked back in and locked the door. I didn't even say a word to them. I just went in the house, I grabbed the car, I went back outside, I handed the car, and came back in the house. I didn't say a word. I just like talk to you and Lynn and everything. I didn't say a word. I just went back in the house. Now I'm going to get out of here. All right, I'm going to go right out. You call there. He knows who you are. Okay? Bring on the phone for him. Send him with me. He can get in touch with me. There's no phone in there. What does he want you in the 4 o'clock? I don't know. I've got your phone in there. This is never Polly's boss. Okay, give him this. My mouth and hands are shaking. I'll be hiding on cough and cold because we don't have that anymore. Alright? This is Polly's boss. You write it. 547-2030. Okay? You have the cell phone. I will not be here because I can't go there anymore. That would be that's their car, yeah, right there, right there, that's right there, car down. What is he going to look for? What does that mean for? That's not right. That car doesn't work. Look for another baby. What do you want that for? I don't know. What can you do with it, like why don't you just come with us now? That'd be a 4. Keep it on you. You keep Jim's card on you. Just stand here for 1 minute. Drop his phone off. Alright, that was fucking freaky. Okay. Annie, where are you? The police are just surrounding my house. Please come get me. I don't have a fucking tag. Hang on. Hang on. All right. 5, 4, 7, 20, 30. No, that's different. They're saying that instead of 2030 is 2033. They're about 33. Alright, you better write down the rest of it. It's me. It's me. Karen. Come and get me right now. You don't find that. I need you to come and get me now. It's a matter of emergency, okay? I'm at home. Bye. I mean now. Well, if I'm still around, I'll pick for you on someone's office. Okay, what do we do about keys? I'm gonna have keys, so something else happened. We can get in. Get fully out. You say get in out of the house. I won't want the top lock, so the kitty's not gonna want the other one. You know, I just I didn't feel it. You still need that? That's your door. If I said nothing, then you say nothing. I said nothing. You said nothing. So whatever they say to you, it's like whatever. Do whatever thing, okay? Do you understand? Yes. You know you should tell you fucking lies. And just look at it and go, just do that. Just please stop. I need that. she's talking to their lawyers. I don't know what they said to her. That gave me a heart attack. I'll be there in a few minutes. Put it on that one.
tape.
Right. Then what we're going to do is you're going to put on the investigator, talk about these two DVDs, and then you will move at the end of that time for admission into evidence of the other DVD.
Yes, sir.
And then, assuming if that motion is granted, then we'll play the other DVD from the beginning. Okay?
Your Honor, I have an objection to P, item P. And I'm sitting here and comparing this to what we just heard on the audio recorder.
May we have the rule re-invoked? Mr. McGuire's still in the room.
He's leaving.
I believe, Judge, that this transcript, which is purported to be accurate, in fact is not accurate in a number of areas. Specifically on page 2, there's, while that large paragraph is being transcribed, I'm hearing Ms. Blake interject words on the other end that aren't on here. The very bottom line where it says we've got serious problems, I believe that was Lynne Blake stating that, not Mr. Tobie. There's a number of areas in here where not only exclamation points are added, there's multiple exclamation points, basically adding whoever did the transcriptions take onto what was going on, asserting exclamation points where there probably should just be periods, and this statement, the very last line with Ms. Blake saying how she's guessing that where they're going and leaving with Paulie, I don't believe that should be in there. And for these different reasons, Judge, I'm objecting to this transcript. I would ask that the tape's admitted, that the tape be played, and the jury, I mean, Mr. Davis can ask Ms. Blake what he wants, but I think they should hear it without the transcript. That's our request.
Judge, it is exactly this type of tape that a transcript is an aid for. The person who was there, who knows the voices, has gone over this, and the state submits it is accurate, and we strongly disagree with the tape by the defense. They can ask her about that on cross, but Ms. Blake, who knows her voice, knows and still went through this with the investigator, and I know they've listened to it numerous times, but you know, the test really is whether it's substantially accurate and whether it will aid the jury in going over it. It's certainly substantially accurate, and we have the witness saying that this is what was said, and you can hear it on the recorder.
We'll join in the objection that Mr. Nielsen just made. As I was following, or trying to follow, with the transcript, the multiple errors in my view, or discrepancies, many of which Mr. Nielsen brought out. And in addition to what Mr. Nielsen voiced as an objection, since the jury has already seen the transcripts that we are now objecting to because they're inaccurate, since the jury's already been exposed to those, I am now going to move for mistrial because I do not believe that it's going to assist them. It's going to mislead them, and not only is going to, but has already misled them, not enhanced their understanding, but misled them and confused them. Especially with the explanation points and other editorial type matters.
when I followed this, outside of the first part, it's still very difficult to understand. But from what I was able to piece together, my hearing of the tape, I think that the transcript is substantially correct. If not word for word, it is not inaccurate so as to be misleading. And I'm making that finding under 105. I don't like all these exclamation points. I got to tell you that. I think that's an editorial addition, and that if these statements are made in such a way that they are in fact exclamations, those are deductions to be drawn by the jury. I don't think it's a serious, in this, as I read these, I read along with the statement, seemed to me that indeed, whenever exclamation points were put in there, that this was a heightened, it seemed to be with a heightened emotion. But having said that, that is still the conclusion of the transcription person and should not be in there. Now, we distributed these before, but the jury only had an opportunity to follow along the first part of this, and so I don't think that the exclamation points affected anybody. But on the other hand, I want, since this is a computer file, I assume, I want you, Mr. Davis, to get the computer file. I want all the exclamation points taken out and periods substituted for those or question marks, whatever is appropriate. I think that to that extent, a transcriptionist can make that, whether it's question or mark or, but an exclamation point does add a bit of editorial comment. There's simply no reason to have that.
If I understand you right, the question marks can stay, but the exclamation marks...
I think the question marks are appropriate here because that doesn't add an editorial opinion. But as far as exclamation point, that means something very specific in the English language. And I think those, if that conclusion's to be drawn, that should be drawn by the jury and not the transcriptionist. So if you want to use the transcription, it's going to have to be without the exclamation points, and we'll redistribute the transcription.
So may we have a moment to do that?
Sure.
Can we let the jury know that we'll be a few minutes so they don't want to think?
Now, in the meantime, do you want to put on Investigator McGuire while that's going on?
I can do that. I think they're probably, it'll be quick enough that there's going to be a break anyway. I'm not sure. I have a feeling that I can put him on to testify, but I'm not sure if this will be done by the time he's through, but we can start that. That's probably the best way to...
Yeah, let's do that. All right, if you would take that transcription of, have it take out every exclamation point in there. You can leave the All right, while we're on this, any objection to the ... dots in here?
No, Your Honor.
Any objection to the question marks?
No, Your Honor.
Judge,
On page 3.
yeah, there's an editorial note under affirmative. I'd ask that be out.
That's just what I was going to say. Please take out affirmative on page 3. Anything else?
What I propose, since we're making changes, is on page 7. A little below the halfway point on the page there, where it says Blake, the last sentence, as she's coming back in, there must be about a 3 to 4 minute pause in there. It's a lengthy pause. I just propose putting some dots in there so at least it's indicative that there is a pause, because that's one we're sitting there just listening to, waiting for something. And
Any objection, just put pause in there.
I think pause would probably be better. All right. Pause, Your Honor. Yeah.
Okay, yes. Pause. Right. Just pause, because we know that was a long pause. All right, and I would prefer that the tape be stopped. Mr. Davis?
Yes, sir.
I'd prefer that the tape be stopped after last page, Tobie, I gotta go, call me. Cut.
So can we have that redacted, the last 3
Yes.
lines attributed to Ms. Blake?
Yes. You see what I mean? The last, because she's apparently speaking with,
Mr. McGuire, Mr. Borelli.
Right.
yeah, I guess, I just would ask what the prejudice is there. We went through this, redacted out the last part of it where there is more there. She's going to testify because there's another portion where she thinks this is some water. She's speaking into it at some point, but I don't know what the prejudice at all is with the fact that she's leaving with Paulie. She can testify she left with Paulie. They're probably going back to shop and Don, whatever it is, I'm on my way to see you, see you in a few minutes. She did in fact go back and meet up with the police.
it's not a problem to redact it from the statement, and it's not a problem to shut it off at the end of that statement. That's the rule.
Oh, I see. When I heard redacting, no one's asking that the tape be
No,
redacted?
just take it out of here, and when we get to that point with the statement, just stop it. Just push the button.
Okay.
For clarification, Your Honor, what you just heard, has that been marked as an exhibit?
Yeah, no, as a, oh wait,
I don't think
no, it has not.
The clerk is shaking her head.
It has not.
In a negative fashion. What is what we heard, is that all that's on that DVD? Because if it comes into evidence and there's something else on it, I'd like to know about it now.
I don't know that. Is there something else on it?
Not other than transcript, but there will be something else out if we take this out. There's going to be that last paragraph on the
sure.
tape. Yes, sir. But, so
And that's it, and then that's the end.
yes, the part we took out, the part I explained to you and Mr. Quarles yesterday, the 3 magic marker marks were taking out the dead time that's on the tape on the time she drives to the Holyoke Police Department from her residence. That was taken out, and that was explained to you yesterday. So that's it. We ended it right here in order to get rid of that dead time.
Okay. All right. So let's bring in the jury and then bring on the investigator for that explanation.
Another problem I have with Investigator Warrior, we're changing the transcript. I wanted him to tell that he went over a transcript with the jury, went over, identify the transcript. It obviously won't be the exact same because the portion is taken out. I assume the defense does not want me to say in front of the jury that the portions have been taken out. So if we can have some stipulation that when I go over the transcript with him and Ms. Blake, where, in actuality, the transcript they went over had in this last part that says she's leaving with Paulie, but I don't intend to get into that for obvious reasons. But I did intend with Investigator Inquiry to ask him to identify not only a tape, but the transcript, and the fact that he sat there and went over that with Ms. Blake.
Right.
And this is a tape, and for purposes of introduction, if I could identify that transcript, although as I said, it's not the identical transcript. It's obviously we've changed it somewhat, even though it's a minor change. I don't feel it's prudent for me to talk about any changes being made to the transcript.
I understand, Your Honor, and I know Mr. Davis's office wasn't ill will when that was done. So I don't have a problem with not making a deal out of it in front of the jury like that.
Mr. Mon? No problem. Okay, let's proceed.
I don't have the transcript, Your Honor. That's what I'm saying. I want to show them the transcript that will be going into evidence in front of the jury. Until the corrections are made, I don't have that transcript.
I thought though what he wanted to do was use the one that's going to be changed and just have us not object to the fact that it was being changed and do it like that.
All that's being changed is taking out the exclamation points. And that one affirmative thing. That's not part of the tape anyway. There are no exclamation points in the tape. There is no affirmative in the tape.
Typically, when I show the witness the transcript, Your Honor, I'm referring to exhibit such and such. Did you go over this with her, as opposed to identifying something that he's gone over.
Right. We'll wait.
So
We'll wait till it's done.
Well, what I was doing, Judge, to try to anticipate, I'm going through this other transcript of the other police car recording and seeing if it's similarly,
All right, do we have our material?
Your Honor, we've seen the cleaned up version, lack of a better way to put it. I've compared it with the one that we had complaints with, and it does, from our perspective, appear to be corrected.
All right, great. Mr. Montague?
Yes, Your Honor.
Okay, let's go ahead and call the jury, then the investigator, and then we'll try to get back on track here.
Yes, sir. And if it's okay, just preface it, I'll ask Your Honor if we can call Ms. McGuire out of order during her testimony for a limited purpose.
Okay.
Thank you.